Good morning, Mr. Francis.
Good morning, Chief Justice.
How are you, sir?
I'm well, thanks.
It's not always easy to be the first candidate, so I'll have a slow start with you. And once I'm happy that you are settled and comfortable, we can then move with high speed. You hold a BA and BA honors and Master of Arts degrees, all in political science. Am I right?
That's correct, Chief Justice.
And you were a lecturer and all the way up to being a senior lecturer at the University of Natal some years back.
That's also correct, Chief Justice.
And then you acquired the Bachelor of Laws degree, and amazingly, you got it cum laude.
Fortunately, thank you. Yes, that is so.
Yes. Since when have you been an attorney? For how many years?
For 28 years, I was admitted in February 1993. So it's 28 years.
And I take it that you've been doing well.
Sorry.
I take it that you've been doing well in practice.
I would like to believe so. I run a fairly successful practice.
And you also have a postgraduate diploma in environmental law.
That's correct. I initially started with a master's degree in environmental law. That's whilst I was lecturing. I completed the coursework component, but then had to return to private practice, and that master's was then converted to a postgraduate diploma.
And you've acted several times as a judge of the High Court.
That's correct, Chief Justice. I've in fact acted for 8 complete terms.
And was it a difficult transition from practicing as an attorney to acting as a judge, or was it not difficult at all?
Well, fortunately, there was a great deal of help from colleagues on the bench. I found it quite an exciting challenge. During my practice, I did chair many quasi-judicial tribunals, so it wasn't an entirely strange experience, but it was a very sharp learning curve.
And for how long would you say you've kept a judgment reserved to the point where you became uncomfortable? What is the longest?
The longest was exactly 3 months. It was a very difficult matter that ended up in the Constitutional Court. But generally, I hand down my judgments within 3 weeks to a month. There are some judgments that require a great deal more reflection and thought. But in fact, in every case, it's definitely within 2 months.
Just to clear this one before questions are put to you, as I did with another candidate, I noticed that you've been a branch member of the African National Congress from 1992 until now. Are you a Kakeri member?
I must confess that I am not a member in good standing. I have not paid my dues. I have not actively participated in the ANC for the last 10 to 15 years. So no, I'm not an active member at all.
So are you a member at heart, or what is the position?
Yes, I consider myself to be a member of the ANC, but not an active member at all. And if appointed, I would have no difficulty resigning from the organization.
Okay, all right. Before I call on the JP and the Premier colleagues, may I have the names of those who have questions for Mr. Francis, please?
I do, Chief Justice. It's Jenny Kane, and good morning to everybody.
Nyambi,
Thank you.
Muimang,
Schlemmer,
Dodovu, Makwanisha,
CJ, I said Tepe. I spoke at the same time.
I've got you here, ma'am. I've got you here.
Thank you, CJ.
After you, it was who? There was somebody after Honorable Dodovu and Commissioner Tepe.
Anisha.
I think it was Mr. Magwanisha, Chief Justice.
Lamola.
And Breitenbach.
Thank you, Honorable
Singh.
and Honorable Singh.
Yes.
Thank you.
Maya.
Sorry, who?
Maya, CJ.
Oh, okay, President. Okay. Honorable JP, over to you, sir.
Thank you very much, Chief Justice and Honorable Commissioners. It is customary, that's my understanding, for commissioners to disclose. I have known Mr. Francis for a very long time, for a period in excess of 30 years. In fact, he was my student at the University of Natal in Pietermaritzburg. I taught him labor law and I think administrative law. He's one of the brightest students I've taught in a very long time. I also taught his late wife, Brenda. So I know him very, very well indeed, and I would like to disclose that. At this point in time, Chief Justice, I don't have any questions for the candidate. Thank you very much.
Thank you, JP. Honorable Premier.
Thank you very much, Chief Justice, and thank you for the opportunity to Mr. Francis. Thank you very much. It is for me an honor to be here on this panel, and for that point, I'd like to bring to you my first question. I am new to this commission, and I must say that I've watched a couple of commissions online. I have also participated in my first commission meeting earlier this week. And as a very proud South African, I'm specifically proud of our constitution. I am proud of our system of having a separation of executive and parliamentary processes to judiciary and judicial processes. And I must say that post my meeting on earlier this week, I was wondering about this specific commission and the processes that we go through. And I was wondering, in my opinion, that whether there's a blurring of the lines between independence of the judiciary and our political sphere and the executive and parliamentary processes in our country. And I was wondering what your thoughts would be on that. Do you see any blurring of these lines, or do you think that we are still on a good course of having that separation of power?
Well, the separation of powers is a democratic principle. It's actually one of the founding principles in the Constitution, and it's designed to ensure that there are checks and balances between the three components of the state. And it's premised on dividing state power amongst those three components so that no one component dominates the other. That's really the reason for having the separation of powers doctrine. And the judiciary obviously plays a very, very important part in that. I think we must also realize that South Africa is an infant in the world or the global stage. It's really a democracy that's not matured. It's still in transition. And one would expect that in societies undergoing transition, that you would have dislocations, problems of the sort. It's a question of how you actually deal with it. But I'm fairly confident, looking from the outside, that each of the three components do stay within their lane, so to speak. So I have a great confidence in the system.
Thank you. Thank you very much, Chief Justice. Can I ask a second question?
Yes, please.
Thank you very much. My second question goes to the environment we find ourselves in now, wearing masks in the middle of COVID-19. And obviously, during this period, I know that in government, we found many innovative ways of doing things differently, of actually changing the way that we operate as government, and in many ways found efficiencies. In your mind, what do you think is the future of hearings? Do you think hearings online will continue? Do you see an evolution and change in our system of courts and how that process is going to? Do you think there's going to be innovation coming in? And I ask that specifically because so many times we seem to find that I think cases pile up, and we see many years of many cases taking to come to fruition.
Yes. I think one of the more positive aspects of COVID-19 is just to bring to the fore how dependent we are on technology. Often we've spoken about the fourth industrial revolution. It's on us. And I think, as I said, a positive aspect is that we now engaging with having to do things differently. So in the court system, certainly where I practice, there have been innovations where cases are heard online, and it has made a tremendous difference. There's going to be a digitization, it's already rolled out in some of the divisions, the digitization of process and the like. So we cannot go back. So I see a bright future as well in the area of the technological transformation of the provision of judicial services.
Thank you, and thank you, Chief Justice.
Chief Justice.
Thank you very much, Honorable Premier. Advocate Kane SC.
Chief Justice, I beg your indulgence.
Or is there a follow-up?
Yeah, it's a follow-up on the first question.
Is it
Honorable Dodovu?
Okay, Honorable.
Yes, I didn't want
I think
to.
you must do everything there. Do everything, please.
Yes, I'll do so.
I want to scratch you here.
Yes,
Yeah.
I didn't want to inconvenience the Premier because he was delivering his maiden question, and my question is based on the first question that he asked about the separation of powers. As you know, this is an old theory developed over centuries by the French philosopher Montesquieu to balance government. What happens in an instance where any of the arms of government is weak? What are its implications to the whole system of government?
Thank you, Commissioner. It's really a subject which I've been particularly interested in. In fact, I started my PhD looking at this particular matter. Unfortunately, I haven't proceeded that very far. But I think the starting point is the Constitution, which we do have, and we've got to live with that Constitution. But one of the challenges I think we face is to reimagine the state in the type of situation that we have, the economic situation we have. Often the Constitution, as I see it, is based on a conception and perhaps underpinnings of a democracy in an advanced capitalist society. We're not that type of society. There's a mixture of first, second, and third world components. So we have to reimagine the state. And if one reimagines the state, one has to reimagine how the courts would approach issues such as judicial review, for example, the issue of constitutionalism and its impact on our jurisprudence in approaching the state. So it's quite a wide topic, but I think it's a topic that one has to debate and give a great deal of thought to.
Lately, if the judiciary, or there seems to be a perception that the judiciary sometimes encroaches on the other arm of government, and they say it's judicial overreach. In your own observation, do you see judicial overreach happening quite often?
I certainly, from my experience, I think judicial overreach, there may well be criticisms leveled against particular courts, but courts really and judges really just apply the law in many instances. And I just want to address the issue generally rather than looking at particular courts.
That's fine, yes.
Often there's a temptation in societies undergoing transition where there's a dominant party and a weak opposition, and I mean weak in terms of numbers, for the judiciary then to act almost like an informal opposition. One should in fact hesitate not to go that way, because as I think a philosopher Hart once said, hard decisions make for bad law. So while you might try to address a problem now, in a few years' time, the political parties might change, but you're still stuck with that hard law. And it'll be difficult then to move against it.
All right, thank you very much. Thank you, Chief Justice.
Thank you, Honorable Dodovu. Advocate KNSC.
Thank you, Chief Justice. Good morning, Mr. Francis.
Morning, Commissioner.
We are permitted to ask 2 questions each. Mine are 2 totally different topics. But the first is to ask you, please, to give us an indication of how you intend to face the challenges, if you're appointed, of there being hostility inter alia between the judge president and the deputy judge president of the Western Cape Division of the High Court.
Well, you know, there are processes in place that I understand, and these processes are unfolding and will deal with the situation. But, you know, having acted in the division for the last 2 years, one often, if you weren't actively participating, you'll think the division's about to crumble. But that's not the case. There's almost a shrill hysteria about that division. The division operates like any other division. Cases are dealt with timelessly. I've never had a difficulty at all in fulfilling my judicial functions, and the courts are running effectively. Problems between the DJP and the JP, as I said, there are processes in place. They must unfold and take their times and take their course. But the courts are operating effectively and efficiently. And perhaps some of the detractors need to come and visit the courts and see for themselves what's going on. But yeah, the courts aren't about to crumble, certainly from my experience.
Thank you. Then, if I could move on to my second question, I'm asking you to postulate a situation where you are sitting in a case and you are yet to hand down your judgment, and then you are privately approached by another judge who's not sitting in the matter. That judge then gives you an indication of a preference she may have as to how it's determined. I would like to know how you would react to such conduct.
Well, judges take an oath to act independently, to dispense justice without fear or favor. And if someone approaches me, and of course it all depends on what the approach is. If it's an obvious approach to say, you will determine this matter in a particular way, then obviously that I'd be offended for one, and I would take the necessary steps to refer it to the Judicial Services Commission. So a lot depends on context, and we know context matters. So, and my experience is there is no difficulty with discussing cases with judges. As an acting judge for myself, I found great comfort in being able to approach fellow judges and to toss around ideas and to perhaps, to talk about matters. Talking about a matter and determining and deciding a decision, that's 2 totally different things. So, yeah, it will all depend on the context.
Chief Justice, may I just follow up, please, with one more question?
Please go ahead, Advocate Kane.
Thank you. I would like you to then confirm, Mr. Francis, that really the dividing line you're drawing between discussions and an attempt to influence is whether you perceive that there's any attempt to influence your independence, and that you would, in the latter case, in an attempt to influence your independent decision, you would hold firm
Absolutely.
Yes, thank you very
I
much.
think that goes without saying. Any judicial officer exercising their functions must do so independently and without fear or favor. They should be impervious to external influence. That goes without saying for any judicial officer.
Thank you, Chief
Follow-up,
Justice.
CJ.
Please go ahead, sir.
Given your relationship with JP, your long history with JP, if he comes to you and say you're going to decide this matter in this way, what will you do about it?
Absolutely, I would report the matter to JSC. I wouldn't have any hesitation on that if there's an attempt to improperly influence. But as I said, context matters.
Thank you.
Honorable Nyambi?
Thank you, CJ. Morning, Mr. Francis.
Morning.
When responding to CJ and in going through the questionnaire from the GCP, it's clear that you deliver your judgments timeously. Why is that important for a judge to deliver judgment timeously?
Well, justice delays is justice denied. I've been a practitioner for, as I said, 28 years now, and I know what agony it is to wait for a judgment, what impacts judgments have to litigants, particularly in the public sector. They need to regulate and structure their future behavior depending on the judgment. So it has critical consequences for the litigants and more generally. So it's only absolutely necessary that justice is served timeously, judgments handed down timeously.
Thank you. My last question to you, given the response you gave to Commissioner Kane about the challenges in the division, if you can share with us the attributes, 2 attributes of a good judge, and share with us those that you think you possess that will come handy to assist you to make sure that that division is functioning effectively, efficient, and at optimal level.
Well, I think there are many attributes that a judge must display. If you only want 2, I think it's integrity would be right on top. And I think a healthy dose of common sense is also very important. Often we as individuals try to overanalyze and overthink things. We should just take a step back, take a deep breath, and see things for what they are. And often issues which seems highly complicated would seem less so if you just take a step back. So I think common sense is very important, is a very important judicial attribute.
Do you possess all of them?
Well, we're all human. I'd like to think I possess some of them, and I strive to possess all of them. Thanks.
Thank you, Mr. Francis. Thank you, CJ.
Thank you, Honorable Nyambi. Advocate Madonsela C.
Thank you, Chief Justice. Thank you, Chief Justice. Good morning, Mr. Francis.
Morning, Commissioner.
Mr. Francis, your qualifications straddle between politics and law.
That's correct.
And indeed, your practice as an attorney, and in KZN, your firm is regularly seen in cases in that sphere of law, politics and law, like local government, provincial and procurement law.
Yes.
Firstly, why did you not apply or make yourself available in KZN and you going to Cape Town? Are you hating KZN?
Yes, there are a number of reasons why. I've always wanted to relocate to Cape Town. It's been a desire of mine. I do have a practice which is based in Pietermaritzburg. It has a branch in Johannesburg, but it has a national footprint. My practice in particular, my personal practice, has taken me throughout the country, and I litigate often in the Eastern Cape, in Gauteng, and in this division as well, in the Western Cape. I'm also no stranger to the Western Cape. My first 2 degrees were obtained at the University of the Western Cape, and my 3rd degree was started at UCT. I have many friends and family in the Western Cape, and quite frankly, I like the Cape.
Yes, happily your friend has briefed me on occasions, but that's besides the point. The second aspect of my question relates to the jurisprudence that has been produced over the years in relation to this field, which I think you specialize in. We have seen a lot of judgments coming, particularly from the Western Cape, that sought to carve out a particular jurisprudence in relation to the appropriation of powers between national, provincial, and local government spheres. Do you think the jurisprudence that has been produced thus far, particularly from the Western Cape, that deals with functional areas of provinces versus local government, is sufficient to demarcate lines of operational space for the 2 spheres of government?
Yes. You know, the Constitution is a source document. The Schedules 4 and 5 set out expressly what the powers of the various levels of government are. And it's really a question of looking at those schedules, interpreting them in the light of the constitutional principles as well. I would imagine that in the hurly-burly of politics, there'll always be an attempt for legislative creep, so to speak. But judges should guard against that. The Constitution is fairly clear on the division of powers. So I think an activist judiciary is important to ensure that those principles and the law enshrined in the Constitution are in fact complied with.
This is a follow-up. Do you think that the contest on functional areas between the various spheres of government is an incident of politics or law?
It would have to be a combination of both. You know, particularly, I suppose South Africa is somewhat peculiar because you have the ANC dominating most of the provinces, with just the Western Cape being controlled by the DA. So there is going to be problems at a political level, but that's not unusual. In fact, it's healthy to have political competition. When it comes to the courts, however, the courts have a document in which to try to resolve those political disputes, and hopefully it will do so in relation to the Constitution and the law that has emerged in relation thereto. But competition, political competition, it's not unusual, it's healthy. It's how it's managed.
So, Chief Justice, I've exceeded my question time. Thank you. And thank you for allowing me.
Thank you, sir. Let me just do a quick follow-up, Mr. Francis. My interaction with colleagues at the German Judicial Academy opened up my eyes to something that we don't do in the South African Judicial Education Institute, and that is part of the induction they give to judges is on economics, communication, and politics. And I said to them, why are you giving an orientation to judicial officers in politics? They said, no, so that when they deal with political matters, they have a fair appreciation of the dynamics around politics and the implications of dealing with political matters in whatever way you're going to deal with them, the implications of dealing with economic matters in whichever way you are minded to deal with them. Now, as an expert in politics or political science, do you think that would benefit South African judicial officers, or would that orientation somehow be inappropriate for the South African judiciary? at such a level?
I would actually support such an initiative. I think the more judges or all judicial officers, the more knowledge they have about the system and the structures within which they have to operate, they probably will dispense justice a lot more appropriately. You know, many lawyers, I would imagine, and many judges would have studied constitutional law at universities, which may have touched to some extent on political systems. But, and I can just speak for myself, having studied political science, I have a far better understanding of the structures of power, how power is articulated through state organizations. And it gives me a much better sense when I deal with matters such as local government or administrative law, or just societal problems in general. I think it would really be of assistance to judges, and it has nothing to do with judicial independence. No matter how much learning and how much teaching you have, at the end of the day, you sit with facts before you, and you've got to exercise your judgment in relation to those facts before you. But I think, as I always say, context is good, and the better you understand that context, the better the output is going to be.
So you believe it would help in, for instance, IEC-related contestations and challenges or disputes within a party or one political party against another? It would give a better perspective there.
I think absolutely, and it just doesn't have to, the education, with due respect, doesn't only have to deal with economics and with politics. It has to deal with also GBV violence. For instance, I would like personally to go through a course of diversity on femicide, to try to understand we know theoretically South Africa is still a very patriarchal society where power relations are heavily skewed in favor of males. We need to know how these power relations in fact affect our decision making and how we actually confront it. So I think the more education judges and judicial officers have in a wide variety of aspects, the better judgments they will ultimately produce. And I would imagine also the better people they would be as well. It would sensitize them to various issues that confront us on a daily basis in the courts.
Thank you, sir. Honorable Mwima.
Thank you, Chief Justice. Good morning, Judge Francis.
Honorable Mwima, you're just too soft. It's difficult to hear you, sir. I think the mic might have been a bit far from you.
Am I audible enough, Chief Justice?
Yes, sir. Thank you so much.
Thank you, Chief Justice. Morning, Mr. Francis.
Morning, Commissioner.
I note that the on your question under section 2, 2.2 and 2.3 and 2.4 makes the case that indeed you are more familiar with the local government regime.
I would like to think so, yes.
From your understanding, do you think that there is enough separation of powers at local government between the executive arm and the legislative arm of a municipal council? And the second point, can you just give a brief outline in terms of what is the difference between a sphere and a tier? Is a local government a sphere of government, or is it a tier of government?
Yes, thank you.
Thank you.
Prior to 1994, local government were in fact tiers of government. They had no independent powers of their own. They existed at the whim of provincial and national government. Post 1994, local governments are independent legislative spheres on its own. They operate exactly the same as a national or provincial government. They are independent and they have a great deal of power. That doesn't appear to seem to have seeped down through the local level. They do operate as independent legislative arms. They have particular duties and functions as development mini states, as it were. They've got a great deal of power. Sometimes it's not recognized, sometimes not understood, and sometimes they just don't exercise those powers, I think, given the structure of power at the national level. But yes, I mean, I'm fascinated with local government, actually. Most of my studies have been in local government, and it really does hold out the promise if properly conceived, of actually improving the lives of individuals. I really think it can. Often the problem in South Africa is not so much that we don't have good legislation and policies. It's just the problem comes in the implementation. We have in fact, our constitution is probably one of the best in the world. Our system of procurement is probably one of the best in the world as well. The problem is implementation. That's where the problem is.
So you agree that these three spheres of government are distinct, are independent, but interdependent?
Absolutely. You know, I think it's section 41 of the Constitution provides for cooperative government, and that's the level where you cooperate. But apart from that, the three spheres of government operate independently. They have distinct functions, and local government plays a particularly important role in society as a whole.
Thank you, Mr. Francis. Thank you, Chief Justice.
Thank you very much, Honorable Muima. Professor Schlemmer.
Thank you, Chief Justice. Good morning, sir.
Morning, Commissioner.
Could you share with us your judicial philosophy? What is...
Prof, it's difficult to hear you. Please bring it closer.
I'll try my best. Is that better? Could you
That's much better, Prof.
Okay. Could you share your judicial philosophy with us, please?
Thank you, Professor. Conventionally conceived, the philosophical approach to judicial decision-making has generally been categorized as conservative, moderate, or liberal. I don't particularly buy into those type of categories. If I had to define or categorize my approach to judicial decision-making, it would be judicial activism, where the Constitution and the promotion of the principles of the Constitution are central to the decision-making project.
And in your interpretation of legislation, how far will judicial activism then go?
Well, you know, there is the idea of constitutionalism. I think that might be. Constitutionalism is really a political philosophy which says that power must be constrained, and that the function of judges is to in fact ensure that that happens. I think judicial activism, when you're interpreting legislation, must always be done in the context of the Constitution. I mentioned, to me, the Constitution is both aspirational and inspirational, particularly aspirational. And when you interpret legislation, I think it's incumbent on judges to try to progressively realize those rights that are inherent in the Bill of Rights. So I think legislation and interpretation of legislation should have that as a basic premise, the progressive realization of rights.
Chief Justice, if I may have another follow-up?
Please go ahead, Prof.
And in connection with the common law and customary law, how far should judicial activism go there? In line, obviously, with the Constitution. But what I would like to know from you is, to what extent do you have to research the principles of common law and customary law before you can apply your judicial activism then?
Well, judges have an obligation to develop the common law and to develop customary law in line with constitutional principles. So, yes, one would have to actively do so.
Thank you, sir. Thank you, Chief Justice.
Chief Justice, may I have a follow-up on that?
Yes, Advocate Madonsela, go ahead, sir.
In relation to the questions posed by the professor, to what extent what is your take on the view that the power of the court to strike down legislative instruments, like a legislation. And so to speak, to countermand legislative acts will give rise to a counter-majoritarian dilemma?
Well, if a court's going to strike down a legislation, there must be good cause, and the reason for doing so would have to find its source in the Constitution. It wouldn't necessarily be anti-majoritarian. It would just be all power, all exercises of public power must have some source in law. And if that legislation is contrary to the Constitution, it must be struck down, and an appropriate remedy must then be fashioned. I don't think inherently that it's anti-majoritarian.
Well, given the fact that judges who are not elected and the legislature is an elected body, surely the voice of the representatives of the majority in the legislature are a majority, as opposed to the unelected courts. That's the argument that raises the counter-majoritarian dilemma sharply. What's your view on that?
Well, we have a constitutional democracy, and we all have to subscribe to it, whether we like the Constitution or not. That is our guiding document. And if the legislature does not comply with provisions in the Constitution, there's no reason, in my view, why a court should not say so. It actually goes down to the heart of the principle of legality.
Thank you, Chief Justice.
Thank you very much, JSC. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Mr. Francis.
Morning, Commissioner.
I have two questions. The first question is over and above your acting stints in the High Court. What other adjudicative experience do you have that you believe is relevant for the role as a judge? And why do you think that experience will be relevant and help you in settling in to the role of a judge were you to be appointed?
Yes. I've acted at quasi-judicial bodies. I've presided over a number, but perhaps the most important is the Provincial Bid Appeals Tribunal. This is a tribunal which is established in KwaZulu-Natal, and it's quite a unique structure. It adjudicates all procurement-related or objections to procurement-related decisions in province. And it operates as a court without the formal trappings of a court. And I presided over that body for 8 years. In fact, I helped develop the practice and procedures in that court. And when I ran that tribunal, I made sure that it was accessible to the layperson. Often we had senior counsel appearing before us, but we also had laypersons appearing before us. We treated all the same. And the practices that I evolved and developed in that particular tribunal was such that it made the atmosphere or the system such that people could come and present their cases. And often we had laypersons coming to present their cases. I also made sure that decisions were handed down within 5 working days. And very importantly also, I insisted that decisions were no longer than 10 pages. It wasn't always possible, but that was it. So decisions handed down timelessly in an accessible manner without technical jargon and the like. I did it, and that practice developed because I was conscious of the fact that people need a voice. They need to object. It's one of the principles of fairness. However, one must also not forget that underlying every procurement decision is the need for service delivery. So I think you could actually match the twin objectives of fairness and service delivery in the way you, in fact, develop your procedures.
Thank you, Mr. Francis. Can I go to the second question? In the feedbacks we received from law bodies, there is a comments about your relationship with the JP, particularly in the dispute between the JP and the DJP, and that you were appointed because you are a friend to the JP. I just wanted your comment on that, so that when we do deliberate, we have your view on that matter. The advocates for transformation raise that, and they say you've managed to clear your name, but I just wanted to give you an opportunity to deal with that in this forum.
Thank you very much, Commissioner, and thank you for allowing me an opportunity to address this issue. Now, as a JP mentioned, I was a student of his in labor law. I think he lectured me in 1989 in labor law and a part of administrative law. I still remember his lecture on legitimate expectation. But after 88, 89, I hadn't had any contact with the JP until I think it was about 1997, 98, when he called me. And he called me within the context of asking me whether I would like to participate in the redraft of Lawrence Baxter's administrative law. Now, for all lawyers would know that that is in fact the key textbook, the seminal textbook on administrative law in South Africa. I had in fact been appointed by Juters and Lawrence Baxter to revise administrative law whilst I was an academic. But unfortunately, when I returned to practice, I had to reluctantly give up that assignment. So the JP phoned me and asked me whether I'd be willing to participate in the redraft of the section on constitutional law. But for the same reason that I had to give up the assignment, I had to reluctantly also decline being involved in that particular project. So that was about 8 to 10 years after being a student. The next time I saw the JP was in 2018, so probably 10 years later. So I hadn't seen him at all, had no contact with him, nothing. I saw him for the first time in 2018 at the High Court in the Western Cape. And I went to go and see him because I had a matter at court on that day, and I thought, let me go and pay my respects to him. I hadn't seen him for decades. And fortunately, he was available to see me. I knocked on his door. He opened the door. He didn't recognize me, believe it or not, but when I was a student, I had a huge afro, and he also had an afro, and he couldn't recognize me. But after a few seconds, we exchanged pleasantries, and he asked me what I was doing. I told him. I also mentioned that I intended to relocate to the Western Cape at some stage, and he asked me whether I'd be willing to put my name forward. I didn't respond. I said I hadn't thought about it. About 6 weeks later, I'd contacted him and said, yes, I had thought about it. Perhaps I'd like to put my application to be considered. And that's how it actually started, me being appointed. So I had no contact with the JP for many, many years. He wasn't a friend of mine then. Since being appointed, he has become a friend of mine, and I value the friendship of the Judge President. But allegations of nepotism and the like, absolutely, quite frankly, it's insulting. Nepotism assumes that you need a leg up, that you're appointed properly, that you cannot do it on your own merits. But with respect, I'd like to believe that my CV, my experience, well, they speak for themselves. Thank you.
Thank you, Mr. Francis. Thank you, CJ.
Including cum laude speaks for itself.
Thank you, Commissioner Tsepe.
CJ, can I follow up on Commissioner Tsepe's first question?
Yes, please, Commissioner Matela Datu.
Thank you, CJ. And
CJ.
Is that you, Honorable Malem, or is that
No,
Commissioner Sigogo?
No, it's me. I wanted to tell him that he forgot to mention cum laude.
You forgot to mention?
Cum laude.
Thank you, CJ, and good morning, Mr. Francis. I just want to follow up on Commissioner Tsepe's first question regarding your experience in quasi-judicial adjudications. I just wanted to, in sitting in quasi-judicial tribunals, I want to tap on you regarding the issue of mediation. In your view, where do you think we should introduce mediation, taking into consideration that our matters take very long and people, that's why communities are actually not understanding our system. Where do we introduce mediation? And secondly, in what matters do you think mediation can actually fast track the court processes?
Yes, I think all alternative dispute resolution mechanisms should be explored so that the courts can deal with, in inverted commas, proper matters. I think mediation is not suitable for matters that are highly conflictual and highly contested. But I would imagine in more family law related type matters, mediation might be more suitable, especially where the parties are going to have an ongoing relationship. You don't want them fighting in courts, which I think might in fact just exacerbate the problems. So to me, immediately that comes to mind is family law type matters. I think the amendment to Rule 37A might expedite matters. But yes, mediation, I think, is an important part of the arsenal which judges ought to have, and of course get training in mediation as well, because that is a specialist skill that one has to acquire.
Thank you, CJ, and thank you, Mr.
Thank you very much, Commissioner. Honorable Magwanisha.
Thank you very much, CJ. Good morning, Mr. Francis.
Morning, Commissioner.
My question is based on your qualification in environmental law. In an era of rapid industrialization, do you think the polluter pay principle is effective at all? Given the fact that polluters, some of them have got deep pockets, what do you think must be done to find the balance?
Yes. Commissioner, thank you. I think environmental and the degradation of the environment, particularly climate change, is one of the greatest existential crises which we face, not only in South Africa, not only as individuals, but globally. So we need to, in fact, give or arm the enforcement authorities to make them better prepared to meet the challenges. The polluter pays principle is a principle it's contained in NEMA, for example, and it's a widely held principle. The problem with environmental law cases is one of proof often, because the damage is so dispersed and there may be so many causes of damage. So one of the biggest problems is actually to determine what was the effective cause of the damage. So maybe one has to look at legislation for strict liability, maybe make strict liability a principle. Obviously, there's constitutional issues with it, but I think the legislation needs to perhaps be tightened up because of the existential crisis that we all face.
Thank you, CJ. Thank you, Mr. Francis.
Thank you, Honorable Magwanisha. Honorable Minister.
CJ, I'm covered. I wanted to ask the question in relation to the complaints by the law bodies. Thank you.
Thank you, sir. Honorable Breitenbach.
Thank you, Chief Justice. Good morning, Mr. Francis.
Morning, Commissioner.
In South Africa, our constitution is paramount. It binds this body, amongst others, to uphold and protect the constitution, and it's clearly set out in section 165 of the constitution. When a judge president of a division operates under the serious cloud of being found guilty of gross misconduct linked to underlying dishonesty, how, in your view, does this serve this injunction? And is it, in your view, desirable?
Sorry, I couldn't quite get the last part of your question, Commissioner.
Said, how, in your view, does this situation serve this injunction to protect and uphold the Constitution? And is it, in your view, desirable?
I'm not sure whether it's my place to address issues
Chief
which
Justice, Chief Justice, it seems to me, with respect, that's a question that falls for this commission to decide in its deliberations, not one that can be answered by a candidate. With respect,
I think the candidate was handling it very well, Advocate Madonsela. He was in the process of answering.
Oh, yes.
Yes. Please go ahead, sir.
Thank you, Chief Justice. Yeah, I really don't think it's my place to comment on the situation as it presently exists, and I would respectfully decline to do so.
May I follow up, Mr. Chief Justice?
Absolutely, Honorable Breitenbach.
Thank you. I'm not asking you to decide the matter, Mr. Francis. I'm asking for your view. You have impressive qualifications and experience in constitutional law. Is this type of situation desirable, and does it serve this injunction? It's not a difficult question. I'm not asking you to decide anything.
Chief Justice, the candidate has declined to answer that question. He has declined.
Let's leave it. Yes, Honorable Malema, I think let's leave it to the candidate. I'm just trying to avoid a situation where colleagues would be stepping in either on a point of order or one point or another. I think the candidate is well able to handle the situation.
Yes, I've made myself clear. I don't think I'd really want to comment on the specifics because there are bodies dealing with this matter. But if I could perhaps just make a general comment, I think every citizen, including judges, they can avail themselves of the rights in the Constitution. One of those rights is to be treated with dignity, regardless of what you may think about them and how you might try to characterize their conduct. But dignity is an essential foundational principle in our Constitution. And I would just hope that those principles are observed as well. Thank you.
Thank you, Chief Justice. My second question, Francis, is I'm pleased you spoke about dignity. It's very important. I agree that everybody be treated with dignity. So I would then ask you, given your general comment, in general, does this type of situation impart dignity to the other members of the Western Cape Division of the High Court?
What situation you refer to with respect, Commissioner?
The situation where the Judge President of the division has been found guilty by the Judicial Conduct Tribunal of gross misconduct. Does this impart dignity, the dignity you speak of, to the other members of that division?
Commissioner, the fact that charges may be leveled justly or justly against a particular individual doesn't affect any other judge. They continue to execute their tasks faithfully and diligently. I think they also believe in the rules of natural justice, that people must be given a fair opportunity to say their say and to have their say. And they also believe in the principles of the Constitution, which allows people to a fair trial and everything that in fact implies. They must be given an opportunity to defend themselves in an appropriate forum. So that's a separate issue to how judges at the Western Cape, and I can't speak on behalf of all of them, but certainly I can speak on behalf of myself, that how I conduct myself, the fact that the Judge President might be facing charges of misconduct has absolutely no effect on me and how I perform and execute my functions. And I would imagine it doesn't affect any other judge as well. Process must be followed. Respect must be given to the rights of individual to challenge if they so desire. And that's a constitutional right that we all enjoy. We can't apply the Constitution selectively.
Thank you.
Thank you, Honorable Breitenbach. Honorable Singh.
Thank you very much, Chief Justice. Good morning to you and to the Premier, JP, and all commissioners, admin staff, and Mr. Francis. Mr. Francis, I note that in your questionnaire under address, you give a particular address, which I shall not repeat, but it's an address in Cape Town. Now, I've come across some mutterings that perhaps that particular unit, the state is covering the tab for that accommodation. Can you tell us whether there's any truth in those allegations, and when did you either acquire for lease or ownership that particular apartment? Thank you.
Thank you, Commissioner. And thank you for actually raising this issue, because it's often raised in the context that my acting appointment has been at great expense to the state or astronomical expense to the state. I can assure this commission that I have not claimed and do not intend claiming any single cent for accommodation. I've actually footed the bill out of my own pocket. I have not claimed any accommodation expense throughout my 2 years acting on the bench. As far as traveling is concerned, as you may well know, certainly in terms of the Act and the regulations governing the benefits of acting judges, I'm entitled to use a pool car or to claim a traveling allowance during my tenure as a judge. I've only used a pool vehicle for the first term, and that was only because I did not have my own vehicle in Maritzburg. But as soon as it became apparent that my tenure would be extended, I used my own car. I, in fact, prefer using my own car. And I've never claimed a single cent in travel allowance. As far as flights is concerned, and I've calculated the number of flights that an acting judge would be entitled to, who acted for 2 years, and I don't want to go into the calculation, but believe you me, it amounts to roughly 54 flights over a 2-year period. I have in fact flown 3 times. So by any stretch of the imagination, that cannot be considered to be at great expense to the state, and certainly not astronomical expense. So allegations to that effect are quite plainly false. And the apartment that I am living in, I've rented it for probably the last 9 months at my own expense.
No, thank you for clearing that, Mr. Francis, publicly clearing that. My second question relates to your directorships that you hold. And I see that you have indicated that you've resigned from most of them. You will resign from the other 2 except for your family trust, which is understandable. I'd just like to know what activities were these 2 entities involved in, Fukaka and Nzokuhle, and Real Associates.
The first company, I was approached by a black entrepreneur. In fact, he was a material scientist who wanted some legal advice. He had a very innovative product. He produced pallets that were biodegradable and environmentally friendly. As you know, pallets are generally made of wood or plastic. Both are no-nos right now. And he asked me whether I'd be interested in not only providing advice, but also startup capital. It was a fantastic project, a good business venture, and of course, it was helping a black entrepreneur. And I did get involved in that. That company, due to COVID, has unfortunately fallen by the wayside, and I don't have any active involvement in it. And if appointed, I will obviously resign. The other company is Real Associates, is a property development company that I was involved in took part as a property developer. And it's still an active company, but it's a company that I have no difficulty in withdrawing, as it's about to, in fact, complete its usefulness. The project that it was involved in is about to come to an end.
All right. And lastly, just as a follow-up, I'm still not too clear on your membership of the ANC. In your questionnaire, you say 1992 to now, branch member, but you're not in good standing and you will resign. Now, if you're not a member, there's no need to resign. So, but anyway, we'll leave that one at that. I think you gave us an explanation, unless you want to expand a bit further on that.
No, I think I've given an explanation. Thanks.
Thank you, Chief Justice.
Thank you, Honorable Singh. Honorable President.
Thank you, Chief Justice. Good morning, Mr. Francis.
Good morning, President.
As you would know, the JSC has since its inception been concerned with the transformation of the judiciary so that it conforms with Section 1742 of the Constitution. Now, within that context, would you please tell me what you understand gender equality and gender transformation to mean?
I think
Gender equality and gender transformation. What do those concepts mean for you? Well, not for you in terms of the Constitution.
I think in terms of, I think it's what's I think it's imperative on the JSC when making a decision on a candidate to consider gender representativity and race when making this decision. And I personally am all for transformation and have, through my practice and through my life, have firmly tried to advance the cause of transformation. I think transformation, as far as gender is concerned, it's not only a numbers game, it's an attitude. It's trying to understand the, as I indicated earlier, structures of power and how they actually manifest themselves in society. So it's actually changes of attitude as well. From my own perspective, I am fully conscious of the patriarchal nature of society, of the fact or of the effects of these power relations on women in practice. And certainly the way I handle my courtroom is to ensure that the constitutional values of dignity and respect for people pervades the courtroom. Whether it's senior counsel and how they interact with junior counsel, how males interact with females, how the litigants or counsel interact with court staff, all those factors are taken into account when I manage that courtroom. So transformation only does, it's, as I said, it's not just a numbers game, it's transformation of the mind as well. I think many of us seem to forget just what a devastating impact apartheid has had on our psyche, both as oppressed and oppressors, and we're still trying to overcome those type of divisions right now. 1994 just didn't do away with some of the past that we had.
What are your thoughts, if any, on the fact that out of the 23 members of the JSC, only 8 are women? Now, I've heard you, and I agree with you to some extent that transformation is not just about numbers. Do you believe that a body that is itself insufficiently populated by women can effectively implement gender transformation, or does that not matter since it's not a numbers game?
I think strides have been made, strides will be made. I always believe that one has to take a fairly long-term view of society. I also believe that the Constitution is aspirational. There's lots of things in that Constitution which we still have to strive to achieve. Equality is one. You know, we may have formal equality, procedural equality, but substantive equality is still lacking. But I think we're still a young society. Great strides have been made in many areas, also just like gender equality. And I have no doubt that with commitment and fortitude, that many of these issues can be resolved in time. All we need is time and commitment.
Well, in the interest of time, I'll leave it here, CJ. Thank you very much. Thank you, Mr. Francis.
Thank you, President. Thank you, Mr. Francis. Your excuse.
Thank you, Chief Justice. Thank you, Commissioners.